If you are watching this video right now, pause whatever you are doing because what I am about to share could directly impact your life, your family, and your future in America. A sweeping new immigration law has just been approved in the United States, and I am not overstating it when I say that 2026 will reshape everything for millions of people worldwide. This is not gossip. This is not guesswork. This is federal legislation that has been enacted and is scheduled to take effect beginning next year. At this very moment, immigration lawyers across the country are working quickly to analyze every section of this law. Families are concerned, students are uncertain, workers are anxious, and the most troubling part is that many people do not fully understand what is happening or how it could affect them individually. That is exactly why this video was created, because over the next several minutes, everything you need to know will be explained in clear, straightforward language that anyone can follow. But here is what is important. Watch this entire video from beginning to end. Do not skip forward. Do not click away because overlooking even one detail could make a major difference in protecting the status you have worked so hard to maintain. That may sound serious, but by the end of this video, you will see why this is being emphasized. Here is who should be paying attention right now. If you are a green card holder, this law affects you. If you are on an H-1B visa, this law affects you. If you are an international student with an F-1 visa, this law affects you. If you have relatives waiting in the immigration backlog, this law affects them. If you plan to sponsor a family member, if you hope to apply for citizenship, if you are currently involved in any immigration process at all, then what unfolds in 2026 could significantly reshape your path. Before going any further, it is important to clarify something. There is a great deal of inaccurate information circulating online right now. Some people are claiming the borders are completely closing. Others are claiming all green cards are being eliminated. None of that is correct, and spreading fear without evidence does not help anyone. What will be provided here is accurate information, a full overview, and practical steps you can take to protect yourself. So what exactly took place? In the United States, immigration is governed by federal statutes. This means that any major changes to visas, green card processing, or enforcement policies must be approved by Congress and signed by the President. This differs from executive orders or internal policy memos, which can be revised more easily by different administrations. When a formal law is enacted, it becomes part of the framework guiding immigration until another law changes it. This new immigration statute went through the full legislative process. It began as a bill. It was reviewed in committees. It was voted on by both the House of Representatives and the Senate. Then it was signed into law by the President. This is not something that can simply be undone overnight. This is binding federal legislation that will shape immigration procedures for years ahead. Why is this so significant? Because the last time immigration reform of this scale occurred was more than a decade ago. Earlier efforts at comprehensive reform failed multiple times. Proposed bills stalled in Congress. Measures were voted down. Nothing advanced. This time, however, it succeeded. And that alone highlights how important this moment is. The law addresses many areas of the immigration system simultaneously. This is not a minor adjustment to a single visa type. It includes green card distribution, visa processing methods, enforcement policies, employer compliance standards, family sponsorship guidelines, and more. Nearly every aspect of the immigration system is influenced by this legislation. The law does not take full effect immediately. Implementation will occur in stages throughout 2026. Some provisions begin during the first quarter of the year. Others will not be fully active until later in the year. This phased rollout matters because it creates a window for preparation. If you understand what is changing and when, you can make thoughtful decisions about your own case. If eligibility standards for a particular visa category become stricter in 6 months, filing under the current rules may be beneficial. If filing fees are set to increase, submitting applications before the increase could reduce costs. Timing has never been more important, and staying informed can place you in a stronger position. Many individuals have been caught off guard by immigration updates because they assumed nothing would change. Delays in taking action sometimes lead to limited options later. Sharing this information now, before the changes are implemented, gives you time to prepare. Next, the specific changes will be outlined. Updates affecting green cards, employment-based visas, family sponsorship, and compliance measures will be reviewed. Each adjustment will be explained clearly, along with who may be impacted. A practical action plan will also be provided, so you understand your next steps. Before moving into those details, take a moment to breathe. This can feel overwhelming. When rules evolve and the impact is unclear, uncertainty can create stress. However, knowledge empowers preparation. Learning about these developments now places you ahead of many others who are unaware of what is coming. Taking initiative is essential. Now let us review the specific changes because this is where it becomes personal. The information will be organized by category, so you can identify what applies to you. Starting with green cards, notable adjustments are occurring in employment-based categories. The new law modifies how employment-based green cards are allocated. For years, the system operated largely on a first-come, first-served model within each preference category. Applicants filed petitions, waited in line, and eventually their priority date became current. That structure is not disappearing entirely, but it is being reshaped in ways that may advantage some applicants more than others. A major change is the introduction of a merit-based point system for employment-based immigration. Applicants receive scores based on factors such as education level, field of study, professional experience, English proficiency, age, and whether there is a job offer in a high-demand occupation. Higher educational degrees receive more points. STEM fields may receive additional consideration. Greater work experience can increase scores. Strong English skills add value. Applicants in prime working years may receive favorable scoring. A qualifying job offer significantly influences the overall total. This means two individuals applying in the same category may not receive equal treatment solely based on filing date. The applicant with the higher point total may receive faster processing. Another applicant with a lower score could experience longer waiting periods. For example, a software engineer with an advanced degree, strong language skills, and an offer from a major employer may benefit. A skilled worker without an advanced degree in a lower demand field may face increased competition. The system prioritizes certain qualifications, and understanding where you stand within that structure is important. Changes also affect H-1B visas. Employers may face higher minimum wage requirements when sponsoring foreign workers. The goal is to maintain fair wage standards. However, some positions that previously qualified may no longer meet updated salary thresholds. H-4 dependent visa holders may encounter additional documentation requirements for employment authorization. International students on F-1 visas should closely monitor changes to optional practical training. Eligibility standards for extended STEM, OPT, may be adjusted, and timelines for some graduates may differ. In family-based immigration, immediate relatives of U.S. citizens remain uncapped. Other preference categories may experience reallocation of visa numbers, with some categories potentially moving faster and others slower. Financial sponsorship requirements are increasing, meaning sponsors may need higher documented income or additional financial support to qualify. Filing fees for many immigration applications are rising. Some increases are substantial. A premium processing option allows certain applications to be expedited for an added fee, offering faster decisions for those who choose that route. For current green card holders, lawful permanent resident status is not automatically canceled by this law. Status remains valid. However, maintaining residence requirements are more clearly enforced. Extended travel abroad may trigger additional review. Address reporting and compliance obligations are emphasized. Enforcement resources for workplace compliance and fraud detection are also expanding. Immigration is not ending. Visas continue to be processed. Green cards continue to be issued. Naturalization remains available for eligible applicants. Family immigration categories continue to function. The primary changes involve procedures, priorities, allocations, compliance standards, and costs. Practical steps can be taken now. Rely on official government sources for updates. Keep all documents current and organized. Monitor pending applications closely. Seek qualified legal advice if your situation is complex. Feeling concerned is understandable. Immigration decisions affect families, careers, and futures. Change can create uncertainty. However, change does not automatically eliminate opportunity. Many individuals will continue achieving immigration success in 2026 and beyond. Preparation and accurate information are key. Implementation will continue in stages throughout 2026, and regulatory guidance may evolve. Staying informed will help you adapt effectively. Stay informed, stay prepared, and continue monitoring reliable updates as more details become available.